Welcome everyone to our webinar on protecting your brand, from idea to commercialisation. We'll start with an acknowledgement of country. We acknowledge and pay respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land our Sydney headquarters is situated on, and the various lands on which those of you are joining us from today. My name is Rebecca Jones and I'm a practice group leader in LegalVision's trademarks team. I'm delighted to be joined today by Blake Knowles, who is a director at IP Australia, and Kathryn Lester, who is a senior trademark examiner at IP Australia. Before we begin today, a couple of quick housekeeping items. You'll receive the recording and slides from today's webinar in your email. Please submit your questions in the chat box throughout the webinar and we'll answer those that we have time for at the end. And please complete the feedback survey after the webinar. Also, all attendees are eligible to receive a free consultation with LegalVision to discuss how we can help you with your trademark protection or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appends at the end of this webinar. In today's webinar, we'll take you through the trademark lifecycle from how to select a good trademark, how to check that it's available, and we'll have Kathryn giving a demo of a useful IP Australia tool that you can use for this. We'll also give you some pointers on what you should do before adopting a new trademark to avoid potential issues. We'll talk about registering your trademark, what to think about in preparing your application, and different stages in the application process, including examination and opposition. We'll also discuss what to do once your trademark is registered, ongoing trademark maintenance, competitor and industry monitoring, and enforcement of registered trademarks. As mentioned, we have Blake and Kathryn joining us today from IP Australia. By way of context for our viewers, IP Australia is the government department responsible for the registration of IP rights and the administration of IP legislation in Australia. From a trademarks perspective, this means that everything to do with trademark registration is done by or with IP Australia, including applications to register trademarks, examination of trademark applications, hearing of oppositions to trademark applications, and recording renewals and assignments of trademark rights. Although we work quite closely together, the roles of LegalVision's trademarks team and IP Australia in these processes are quite different. IP Australia is an impartial government entity that facilitates and examines trademark applications and oppositions. On the other hand, LegalVision's trademarks team represents trademark applicants and opponents in various applications and proceedings before IP Australia. I think our viewers will find it very insightful to hear from both perspectives today. As we mentioned, at the end of the webinar, we'll be answering some of your questions, so please submit them throughout the webinar in the chat function and we'll answer as many as we have time for at the end. And now, Blake, can you please take us through some considerations to bear in mind to ensure you select a good trademark for your business?
Okay, thank you, Rebecca. So great to be here today. So the first thing I'm going to discuss is, from an IP Australia perspective, what makes a really good trademark? What makes a trademark registrable? So a trademark is intended to distinguish one trader's goods or services from those of someone else. And that's basically the underlying rationale behind the Act, and it underpins the grounds for the grounds that we might reject a trademark on. So there's three main criteria that we look at. The first thing is distinctiveness. So we shouldn't be registering something that other traders are using or may want to use because of its descriptive characteristics. The next thing is that your trademark should be sufficiently different to existing pending or registered trademarks. And the last thing we look at is there other inherent reason in the trademark itself why it's not appropriate that it be registered? So we basically look at, is there something inherently confusing about it? Is it illegal to use a particular aspect of that trademark, or would the trademark cause offence in some way? Next slide, please. So the first of those criteria that I'm going to have a look at is distinctiveness. So the Trademarks Act basically talks about trademarks being something that are capable of distinguishing. And when it says capable of distinguishing, essentially means it's something that will distinguish your goods or services from those of someone else. And that basically means that a trademark is not something that other traders would have a legitimate desire to use. So trademarks that might be difficult to register include direct descriptions of the goods and services, such as Angus beef rissoles for meat products, geographical names that may indicate where the goods or services might come from. So for instance, if you're a sandblasting business in Sydney and you apply for the word Sydney sandblasting, that trademark is not likely to be considered capable of distinguishing. And laudatory expressions that extol the virtues or some aspect of the goods or services, such as perfect pizza. Trademarks that might be easier to register are those that allude to the goods or services or their qualities or characteristics in an unusual way. Trademarks that are geographical names for places where it's unlikely that a person in Australia will be providing the goods or services from. Or other trademarks that are unusual grammatical constructions or otherwise not something that other traders might need to use. It's also important to keep in mind that we don't just object to trademarks if you apply for the exact wording of a descriptive term or phrase or a laudatory term or phrase. We can also object to trademarks if you've got a slight variation of a descriptive word or phrase. And the reason we do that is if we grant registration for a slight variation of a particular descriptive or laudatory term, that might allow you to then potentially impact other traders' rights to use the actual descriptive phrase or term. So overall, the best trademarks are those, in my perspective, that describe the goods or services or laud the goods or services in some way, but do it in an unusual way that other traders aren't going to legitimately desire to also use. Because these trademarks have the best of both worlds in that they're distinctive and registrable, but they're also conveying a positive message about the quality or characteristics of a particular trader's goods or services. Next slide, please. So we're often asked to consider composite trademarks. Now, a composite trademark is a combination of different elements, usually word elements and image elements, what we call device elements. And composite trademarks often include descriptive words as one of their features and a more distinctive device element. So the question we're asked is, well, can I register this combination of elements as a composite? And the short answer to that is sometimes you can do that. And the example I've got up on screen of native berries and Australian beef are two good examples of where we will register a composite mark and where we probably won't register a composite mark. So native berries, assuming that the goods are in fact native berries, the words by themselves would be considered highly descriptive and difficult to register. But in this case, we've got a composite combining a distinctive parrot device and a broader logo with the words native berries. Now, whether a composite is registrable depends on the relative prominence of the distinctive and the descriptive elements. In this case, we have a very significant distinctive element, which is the parrot device, and an equally prominent word element, which is native berries. But as a whole, neither element dominates the other. So we would consider in this case that the presence of the distinctive parrot element is enough to render that trademark as a whole distinctive and registrable. Conversely, if you look at the example on the right-hand side of Australian beef, the words Australian beef are obviously highly descriptive. But when you look at the device elements, the pictorial elements, they're not particularly distinctive either. The background is a simple border that is common to many types of logos and devices, and the small map of Australia is also descriptive in the sense that it re-emphasises that the goods are of Australian origin. So that is a trademark we would generally not consider inherently distinctive and registrable. Now, the advantage of a distinctive composite mark is that it's easier to register than just descriptive words by themselves. However, the disadvantage is you only get rights in the mark as a whole. So you don't necessarily have any rights to stop other people using the descriptive words that form part of your composite mark. Overall, registrability must be balanced also against other factors. It's no point having a distinctive composite mark if that's not going to work for your business from a marketing perspective. And that's something where professional advice is essential. Next slide, please. The second aspect of registrability that we look at when we're examining trademarks is your trademark sufficiently different to other trademarks that are already registered or are pending registration? Now, there's two major things that we look at. We look at the similarity of the marks themselves, and we also look at the similarity of the goods or services that are covered. When we're looking at similarity of trademarks, can run into conflict when they're either substantially identical or deceptively similar. So substantially identical pretty much indicates that the trademarks are virtually the same. Side-by-side comparison having regard to the essential elements of each trademark. Deceptively similar is a much broader test and generally indicates that the trademarks might be confused based on consumers who are ordinary consumers of those particular products having an imperfect recollection of those marks, and the fact that consumers may also at times only remember the essential features of the mark and not every single feature of the trademark. And basically what we're looking at is, would a consumer seeing both marks at different times and having an imperfect recollection of every element of the mark be potentially confused that those trademarks were used on goods that came from the same source or were otherwise connected in some way? When we're looking at the goods and services covered by the trademarks, we're not just looking at whether the trademarks cover the exact same goods or services. What we also look at is whether the trademarks are covering similar or closely related goods and services. Now, there's a number of tests we use, but when we're comparing goods and services versus services, what we tend to look at is the nature of the respective goods, the similarity, the purpose of the respective goods, and whether the respective goods are provided through the same trade channels. So a good example of that would be shoes and socks. Those goods aren't the same, but they have a similar purpose in that they're intended to cover the foot. They have a similar nature in that they are items of apparel, and they are often sold through similar trade channels. So the same or close aisles in a department store or in specialty shoe stores. So when you take all of those factors into account, we would conclude that shoes and socks are similar goods, and therefore trademarks that are similar, one for socks and one for shoes, would run into conflict with one another. Okay, next slide, please. So my next slide is mainly to highlight the extent of the test for deceptive similarity and some of the factors that we take into account when we're deciding whether two marks are deceptively similar. So firstly, distinctive words are more likely to lead to confusion when they're similar than descriptive words. And the example I've got on the left-hand side is from a recent decision from a trademark opposition where the hearing officer had to consider whether the words Vovo and a trademark, the word Vovo and a trademark containing the word Volvo were deceptively similar. Now, the goods in this case weren't motor vehicles, as you might expect from Volvo. They were actually air conditioning apparatus, because Volvo has a trademark covering a broad range of classes for different goods and services. Now, Vovo and Volvo side by side are clearly not the same, so those marks aren't substantially identical. However, when you take into account deceptive similarity and imperfect recollection, the hearing officer concluded that given that Vovo and Volvo are very similar in construction, only differing by one letter, and that the items on which they were used, so air conditioning apparatus, are likely to be purchased based on visual inspection, that a consumer of those goods relying on imperfect recollection might be caused to wonder whether those goods or services originate from the same trader. Now, it's important to realise here that when deciding that, the hearing officer wasn't taking into account the reputation of the word Volvo for motor vehicles. The hearing officer was assessing it based on the look and the sound and the meaning of those two marks and coming to their conclusion. And that conclusion was deceptive similarity. You contrast that decision with the case on the right-hand side, which was from a recent federal court decision where the federal court had to consider whether the North Agency and the agency were deceptively similar. And the services that were relevant in that case were real estate agency services. In that case, the federal court said these trademarks are not deceptively similar because they have a different emphasis. So the North Agency means something different to the agency by itself. And also because for real estate services, the word agency is commonly used by many traders, and therefore its presence in two trademarks for different real estate businesses is not likely to lead to confusion. It's also important to take into account the manner in which goods and services, which trademarks are used and how goods and services are ordinarily provided. So where a trademark is used in a circumstance where sound is more important, so for instance, where you purchase items over a counter, so for example, when you go into a chemist and you're ordering medication, obviously the sound of the mark and similarities in sound might be more important than similarities in the look or meaning of a particular trademark. Conversely, where something is purchased based primarily on visual inspection, so for instance, online or being picked up off a shelf in a self-service supermarket, the look of the trademark becomes more important compared to the sound. But at the end, it's a balancing act taking into account all aspects of a trademark, so look, sound, and meaning. Another point to note is that confusion is generally less likely where the goods and services are highly specialised or expensive, and that's because consumers are more likely to spend time inspecting the goods and taking note of the differences in the respective trademarks. Next slide, please. The final point I want to touch on in terms of the reasons that we look at potentially rejecting a trademark is whether the trademark is confusing, illegal, or offensive. So an example of something that might be considered confusing is use of the term vegan, particularly on goods and services that are clearly not suitable for consumption by those who follow the vegan lifestyle. Some other examples might include the use of geographical references on goods, particularly where the geographical origin of the goods is an important purchasing consideration. So things like wine, produce, meat, and also the incorrect use of technical terminology in particular fields. And the example that I've put up on the screen is the use of generic pharmaceutical non-proprietary names in a manner that might lead consumers or pharmacists to think that a particular medicine contains an ingredient that it actually doesn't. Illegal marks, so marks that are prohibited by law. There are various pieces of state and territory and Commonwealth legislation that prohibit the use of certain terms in certain contexts. And we will raise objections where those particular terms form part of a trademark in some cases. So a good example of that is the use of the word bank in relation to financial insurance services and insurance services. The use of the word bank is prohibited or regulated under the Banking Act, and you have to be a particular type of institution to use that word or otherwise have permission from APRA. Similarly, various Defence Force insignia and terminology and the Red Cross device is prohibited under various pieces of legislation for use in certain contexts unless you have permission from the Minister of Defence. Finally, offensive trademarks. What are defined as scandalous trademarks under the Trademark Act? So basically anything that we perceive might cause offence to a significant portion of the Australian community can be deemed scandalous and subject to grounds for rejection. Anything that is racist or misogynist or incites hatred or violence is, generally speaking, going to attract an objection that it's scandalous and will be highly unlikely to be registered as a trademark. Anything that insults a particular religious or cultural group is also likely to fall into that category as well. Swear words are interesting because swear words may or may not cause offence based on their context of use. So obviously, if you are using the F word on a product that is aimed only at adults, so such as adult toys or adult material, that's less likely to cause offence, and in most cases is not going to be subject to an objection. However, if the same word was used on confectionery or children's toys, obviously the audience for that product, that word is less appropriate for, and its use is more likely to cause offence, and we're more likely to raise an objection. Next slide, please. Okay, so I'm about to hand over to my colleague Kathryn Lester to talk about our Trademark Checker program. So Trademark Checker is a service that we offer free online, and it's an AI-assisted search for a couple of things. The first is it assists in identifying potential issues that trademark applicants might face in terms of whether their trademark is too similar to an earlier trademark or whether their trademark is likely to get an objection that it's not distinctive. Important thing to keep in mind about our Trademark Checker service is it's not intended as a substitute for a clearance search by a trademark attorney or a lawyer. It's merely meant to give some indication early on in the process, particularly around the ideation phase of selecting a brand, whether there's likely to be obstacles or not. But it will not tell you whether you are free to go ahead and use this trademark or not. That's the job of a trademark lawyer or attorney. Now, with that said, I'll hand over to Kathryn to give you a bit of a demonstration on our Trademark Checker service.
Thanks, Blake. So this is the Team Checker tool, as Blake mentioned. It's a free online tool that involves an AI or computer program doing the checks for the two most common issues that come up with a trademark application. That's the distinctiveness and the similarity that Blake mentioned in the previous slides. The cost there is if you decided to apply at the end. So if I click Start, this page shows some examples of the sort of things that people could find as an issue when the application is looked at. I won't go into them in any detail because they've mainly been discussed on the previous slides. And there's a disclaimer and a privacy notice. So you can either check just a text mark, so just type in what you want looked at, or you can upload an image file, and the image file can either just have a device or a device with some words. For the purpose of this demonstration, I'll go for just a word one. And this example has been chosen to trigger specific things in the system. It's not necessarily a good trademark. So if I go next, this page is to choose the goods and services you plan to use the trademark on. It's important to select the goods and services appropriate to what you plan to do, because this will determine the scope of your trademark protection. So for Hobart bags, if I want to use the trademark on bags, I'd need to select those types of goods. but I would not be covered, for example, for a retail shop. So if I type in bags, the system gives up some examples of the things I might want to select. It tries to sort them in what it thinks is most relevant, but it's important to scroll down just to make sure that you are getting what you plan to use your trademark on. At IP Australia, we sort the goods and services into various classes to help us search the register. And this is also how we calculate most of our fees. So if I decide to select bags, you can see the system has shown the cost if I decided to apply at IP Australia at the end. And if I select more items in this one class, the price doesn't change. But if I scroll down and select, say, cricket bags, the price goes up. If what you're looking for is not listed in the short list, then you can click on Show More Options. And there's a help video and some links for information on selecting your goods and services. So if I go next, and it takes a couple of seconds for the AI to look at the trademark you've submitted to it, and then it comes up, in this case, with the issues it thinks are a problem. So as I said, it only looks at distinctiveness and similarity. It does not look at the examples Blake had in the last slide for scandalous, Red Cross, plant, wine, that sort of thing. So in this case, it's found that Hobart Bags has a distinctiveness issue. That's because this is similar to the Sydney sandblasting example on Blake's slides, because Hobart's a geographic location. And again, there's more links and help videos for information around distinctiveness. If we scroll down, these are the marks that the AI thought were similar. So it gives a maximum of 20 results, which is generally sufficient for most applications. And it tries to sort them in what it thinks is most relevant. So it puts Hobart at the front, but there may be results that are still a problem for you further along the list. It doesn't get things right 100% of the time. So it's important to look through all the results. And you can click on the details to have a look at what the trademarks individually have chosen to use for their goods and services, their owner details, that sort of thing. And again, there's more videos and links for information. So at the end, after you've had a look at the AI's results, you might want to go back and edit your trademark further, changing the goods and services or changing the trademark. Or you might want to start again completely and overwrite what you've submitted so far. If you do decide you'll want to apply, you can check your trademark details and then click Apply. The system will still let you apply even if it's come up with some issues. That's because you might have a way to overcome them, or you might want to discuss with the examiner your options. But once you pay the fee, the examiner's response is the one that matters. So there are frequently asked questions you can have a look at. The application process, the timeframes, and the fees. And again, there's a reminder here, this is an automated check. The AI is right most of the time, but it's still not 100%, and it will be up to the examiner to determine the final outcome. And at this point, you would log in or sign up for an IP Australia online service account to submit your application, and it's at this point you pay the fee. So that's the see and check-in tool, and now I'll hand back to Blake.
That's over to me, I think. Thank you very much for that, Kathryn. That's such a fantastic tool, really useful for, like Blake mentioned, businesses that are in the early stages of brainstorming ideas. Say you have a list of, 5 to 10 names that you're thinking about potentially adopting. You can jump online, you can see whether there's any issues that might come up for some of those names, and you can essentially knock out the high-risk ones. So you're not wasting any time going further down the process with ones that ultimately might land you in hot water. So it's a really fantastic tool. Okay, so if we could have the next slide, please. Thank you. Now, before you adopt a new brand name, you're going to want to make sure that use of it isn't going to result in potential legal action against you by the owner of another similar trademark. As Blake discussed earlier, the Trademark Act requires that trademarks are sufficiently different to one another to avoid any risk of consumer confusion. Now, this can come into play both when you're applying to register your trademark, as well as when you're using your trademark in the marketplace. So when you go to when you go to apply to register a substantially identical or deceptively similar trademark, which is similar to one that's already on the register in Australia, that earlier registration is likely to block your application during examination. On the other hand, if you go to use that substantially identical or deceptively similar trademark in the marketplace, you would be at risk of an action for trademark infringement by the owner of that earlier similar registered mark. Now, the TM Checker tool is a great place to start when you're brainstorming your new ideas and you want to see if there's going to be any issues. But what should you do if you locate, say, a third-party registration that's the same or similar to your proposed trademark, or you think there might be an issue such as distinctiveness, but you're not sure how serious it might be? In those instances, it's really useful to get some legal advice. There might be ways that you can navigate or overcome particular issues that are specific to your circumstances. So it's not necessarily a black and white case every time. There may be ways that you can still proceed with your name or the desired brand name that you want to apply for, but there might just be a bit of extra work involved. Now, bear in mind that Australian law recognises rights in unregistered or common law trademarks as well. So these are marks that have been used in the marketplace, but perhaps not formally registered. Now, these marks won't be raised by an IP Australia examiner during examination of your application because examiners focus on the trademarks register. But these unregistered rights can still be used by a third party to bring an action against you or to oppose your application. Now, with that background about how to select a good trademark and what types of trademarks are likely to be registerable, you might be wondering why you should register your trademark. It's not mandatory to register your mark in Australia, but there are a number of benefits. To provide some context to this, it's useful to have a brief understanding of the legal framework that recognises and protects trademarks in Australia. Now, the Trademarks Act is the dedicated trademark legislation in Australia. So this protects registered trademarks only. The owner of a registered trademark can take action against a person making unauthorised use of a substantially identical or deceptively similar trademark in relation to goods or services for which the trademark is registered or closely related goods or services. And that's provided for under Section 120 of the Trademarks Act. Another avenue for protecting your trademark rights in Australia is misleading and deceptive conduct provisions. So an action for misleading and deceptive conduct falls under the Australian Consumer Law, which forms part of the Competition and Consumer Act 2010. This provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. So this can arise when a party uses a trademark that is too similar to an existing trademark, whether registered or not, and thereby mislead or deceive consumers or be likely to mislead or deceive consumers. And the third action that I wanted to cover off briefly is the common law tort of passing off. Now, passing off can occur when a party presents their goods and services as those of another trader, which may be done by marketing and selling their goods and services under the same or a confusingly similar brand. To be successful in an action for passing off, the plaintiff would need to establish that they have a reputation or goodwill in the brand, that the third party has made a misrepresentation, for example, by offering their goods for sale under the plaintiff's trademark, and that as a result of that misrepresentation, the plaintiff has suffered or is likely to suffer damage. Now, the benefits of trademark registration. One of the most important ones I would say is that it grants you exclusive rights to use and to authorise the use of your trademark. That's under Section 20 of the Act. It allows you to take action for trademark infringement under Section 120 of the Act. It can be easier to establish than other actions. For example, when you're bringing an action for trademark infringement, you're relying on your registered rights, which are on the database. You have your trademark certificate of registration, and that's what you're relying on to establish infringement of your trademark. Whereas when you're bringing an action for passing off or misleading and deceptive conduct, you need to put on a lot of evidence to show that you have the required reputation. So bringing an action for trademark infringement can have a lower evidentiary burden. The other thing to bear in mind with trademark infringement actions is because it's based on your trademark registration, which is registered at a federal level, you often get broader geographic protection. So if you were, by comparison, trying to bring an action for misleading and deceptive conduct or passing off, the reputation that you're able to establish by providing your evidence might be limited to a specific local geographic area, whereas when you're relying on your trademark registration, that's Australia-wide because it's registered at a federal level. The other important aspect and benefit for trademark registration is that once your trademark is on the register, so once you've applied to register it, you receive a priority date, which is generally your filing date, and that then acts as a block to later filed applications. So if you file your application and then a week later someone else applies to register a similar trademark, your application would take priority over that later filed application. Now, once you've done all your due diligence, the next step is to prepare your application for filing with IP Australia. Now, Kathryn touched briefly on the classes of goods and services before. So there's 45 different classes. 1 to 34 cover different categories of goods, and 35 to 45 cover different services. Some of the common classes that we see would be Class 9 for software goods, Class 25 for clothing, and Class 35 for retail services. It's really important to get this right as it defines the scope of your protection. And bear in mind that trademarks can coexist for unrelated goods and services. So you want to cover all of the goods and services that you're going to be providing under your trademark to avoid another third party perhaps applying in a class that you really should have protected yourself in. Now, Blake, do you want to take us through the next steps in the application process?
Thanks, Rebecca. So I'm just going to give a little bit more information about what happens when you file a trademark with IP Australia and the different ways that you can do that. So there's two avenues for filing a trademark application. The first is our trademark head start process. Now, trademark head start is a relatively quick turnaround service where we offer a preliminary assessment after which you can elect to file with a formal, proceed with a formal trademark application. So the benefit of trademark head start is you get an early indication of whether or not we're likely to raise objections if we were to formally examine the trademark later on. Once you receive your trademark head start assessment, you can then elect to proceed with a formal application, and you'll receive a confirmation formal examination report several weeks later. The disadvantage of trademark head start is it does cost slightly more, but generally most customers feel that cost is offset by the benefits of getting the preliminary assessment and faster formal examination. The other way you can file, I'll add one more point about trademark head start, is the other disadvantage of trademark head start is you don't get a filing date on the day you file your request. You are only allocated a filing date once you elect to proceed with a formal application. So that's a few days difference between those two times, and normally a few days won't make any difference, but in some cases, if a conflicting mark has been filed around about the same time as your own mark, that few days might be important. But generally speaking, a few days is neither here nor there in the application process. The other way that you can file trademarks with IP Australia is by filing a standard application. Now, a standard application is given a filing date on the date it's actually filed with IP Australia, provided that the application contains the minimum amount of information we need to assess your trademark application. So the name, your address for service of documents, the trademark, the goods and services that you want covered. Once we receive your application, it's then put in a queue to be examined by one of our examiners. Once the examiner takes the trademark, they'll assess the trademark on a number of grounds, including the things I've spoken about previously, whether it's distinctive, whether it's too similar to an earlier trademark, or whether there is any other inherent reason why it's not appropriate that the trademark be registered. The examiner also looks at a number of formalities, for instance, whether the owner is someone who has legal personality. So there's an individual or a group of individuals who've been individually named, or a company or some other incorporated body. The examiner will also look at whether the goods and services are clear and whether they've been claimed in the correct class. Once the examiner has looked at these things, what they'll do next is they will issue a report. And if there's no issues with your trademark, the report will be a notice of acceptance saying we've accepted your trademark and we intend to advertise it for opposition purposes, which I'll come to a little bit later. If the examiner does find problems with your application, the examiner will explain those in the report and you'll be given 15 months to file a response to overcome those issues. Now, it's important to realise that that 15-month period isn't your deadline for filing your submission with IP Australia, it's your deadline for overcoming the objections. So you get multiple chances to file submissions during that period, provided that each of your submissions is progressing the matter in some way. Okay, if you manage to overcome the objection, the trademark is then accepted and advertised for opposition. And any person can file a trademark opposition. And if no person files a trademark opposition, then your trademark proceeds to registration. Oppositions are only filed in about 5% of cases, so they're statistically uncommon, but they still do happen from time to time. Many of the oppositions that are filed are also resolved during the opposition process by negotiations between the parties. So receiving an opposition doesn't always mean that you're going to be up for an expensive process or it's going to be a long process. My audio cut out. Can you hear me? Okay, thank you. So I just cut out there talking about the opposition period and what happens. In terms of timeframes for examination of your trademark and registration of your trademark, examination usually, depending on the way you file your trademark, occurs within 2 to 12 weeks of filing, and registration generally occurs if there's no objections or no serious objections within 6 to 12 months. If you get an opposition to your trademark, the time period for that is longer. It can take, anywhere between 18 months to 2 years sometimes for that opposition process to resolve, but it really depends on the circumstances of each case. So next slide, please. So what do you do if you get an adverse examination report that raises objections against your application? Well, there's a number of options that you have. The first option is just to file legal arguments saying we got the objection wrong. And we do often get objections wrong. And that's a consequence of the system sometimes being a little bit ambiguous and there being a lot of grey areas around what is a distinctive mark and what is a trademark someone is likely to confuse with an earlier trademark. So you're welcome to file submissions either directly or via a legal representative, basically saying, well, we think you've misapplied the law or you've misunderstood what the trademark is or you've misunderstood the market. There's a number of ways that you can go about arguing that our objection is incorrect. If we receive those arguments, we'll give them due consideration and often we'll withdraw our objection or potentially restate our objection so it applies to a narrower range of goods or services. The other option that's commonly used is deleting goods or services. So often our objection may not relate to all the goods.
Oh, looks like we've lost Blake. So often an objection doesn't relate to all of the goods or services. So you'll often be able to amend your specification in a way that removes the objected to goods or services, which allows the remaining goods and services to proceed through to acceptance. And I think, are you back, Blake?
Yeah, thanks, Rebecca. I heard what you were saying there.
Goods and services part.
Okay, great. the last option that's often considered is filing evidence of use. And evidence of use is used mainly in two contexts. One, if your trademark is not considered distinctive, you can file evidence to demonstrate that it has become distinctive through use in the market, or even in some cases that through intended use of the trademark, it will become distinctive. And what that evidence is meant to demonstrate is that the trademark has acquired what we call a secondary meaning, where it's seen as a brand rather than as a descriptive or laudatory term. You can also file evidence of use in situations where an earlier trademark has been found too similar to your own. And the most common situation is what we call prior use. So a trademark applicant has been using their trademark for a long period of time, but hasn't applied to register it. And in the meantime, someone else has registered something similar. If you can demonstrate that your use of your trademark for your goods and services was before the filing date of that person's trademark, you can have your trademark accepted based on prior use. Another option for dealing with conflicting similar trademarks is honest concurrent use, which is basically a discretionary provision where we look at whether you adopted your mark honestly, and because of the extent to which you used your trademark, even if that use commenced after the date of filing of the earlier trademark, that it's fair and reasonable in the circumstances that you should also be granted registration. The biggest thing to take into account with honest concurrent use is that if you knew about the earlier trademark, or if you took no steps to inform yourself that there might be a similar earlier trademark, it makes it really difficult to establish that your use is honest and to obtain registration based on honest concurrent use. And finally, we might accept at times, or we commonly accept, letters of consent. So an earlier trademark owner has provided you with a letter saying that they do not object to your trademark being registered, notwithstanding that it's similar to your own. And that's commonly accepted as a reason why we might withdraw an objection that your trademark is too similar to the earlier mark. I'll turn over to Beck now to give a legal perspective on responding to objections.
Yeah, I just wanted to jump in there and say that the trademark examination phase is a great example of where the roles of IP Australia and LegalVision are quite different. So Blake discussed what an IP Australia examiner will do in terms of assessing your trademark and any materials that you file for them to consider. On the other hand, LegalVision can assist you with devising the strategy and preparing the relevant materials to submit to the examiner. This might include legal arguments, evidence of use, or even providing assistance with negotiating consent from the owner of a cited mark. Another part of the process where LegalVision acts as your advisor and representative is during the trademark opposition process. So oppositions are heard by an IP Australia hearing officer, but they act as an impartial adjudicator, whereas LegalVision can help you put forward your case for consideration and even negotiate a potential settlement with the other side in some cases. Now we've got a couple of slides left, Blake. I'm mindful that we are running tight on time and I'd like to save some time for a couple of questions at the end. So should we just do a 30-second on each of the next slide and then we can get into some questions?
Yep, no problem. So quickly, trademark oppositions. Your trademark is accepted for opposition. It then gets advertised for 2 months. And by advertised, it's published in our journal, and the status on our trademark search online is updated to indicate this trademark is open for opposition. Any person can oppose registration of a trademark, but they have to have grounds for doing so under the Act, which includes those grounds I've spoken about before: distinctiveness, similarity of marks, or other reasons. And there's additional grounds at the opposition phase on which a trademark can be opposed. But probably my key message with trademark oppositions is, even if you don't, even if you're fairly confident dealing with the system, it's probably one of the best times to get some legal advice before you go ahead with an opposition, because it can be a complex process and it can have cost implications too at the end of the day. So, Rebecca?
Yeah, so did you want to? You got one more slide.
Yeah, I'll go into my next slide. I've got another slide, yep. So my final slide is dealing with
Oh, we've lost Blake again. So I'll just summarise the points on this slide. Your trademark is registered for 10 years and you can renew it for subsequent 10-year periods by paying renewal fees. You should bear in mind that you should use your trademark to keep it valid, otherwise it might be removed for non-use. You generally have the first 3 years to make some use of the trademark, so you don't need to use it immediately upon registering it. And in some cases, a trademark can also be cancelled, including by way of court action if it shouldn't have been registered in the first place. And finally, a registered or pending trademark can be assigned from owner to owner. Last slide, please. Now, once your trademark is registered, you can you can use it to bring an action for trademark infringement if someone makes unauthorized use of your trademark. It's important that you don't allege trademark infringement before your trademark is registered. So if your application is only pending, don't go around making threats of trademark infringement against third parties, because that would constitute an unjustified threat. You should keep an eye on the marketplace and the activities of competitors. And if you become aware of any instances of consumer confusion, you should investigate. If someone is making unauthorized use of your trademark, you should take swift action. Don't become complacent and don't allow unauthorized use to go unchallenged, because this can dilute your rights and also make it more difficult to enforce your rights against that third party down the track if, say, they've been using it for a few years. It's also worthwhile monitoring the trademark database to keep an eye on applications that have been filed and oppose if necessary. LegalVision provides a free tool to members that allows you to track competitors' trademark filings, which can be very useful. And finally, once your trademark is registered, you should use the R symbol to put third parties on notice of your registered rights. But bear in mind, you can't use the R symbol until your trademark is actually registered. Prior to that point, you can use the TM symbol. Now, that concludes the main part of our webinar. You might find our publication on Trademark Essentials useful. You can download it now by accessing the handout panel of this webinar or scanning the QR code. We also have an upcoming event that may be of interest to you. This is Data Security Compliance, Legal Strategies to Avoid Massive Data Breach Penalties. This is on Thursday, the 7th of September, and you can register now via our website. Now, we're going to answer a couple of questions shortly, but I'll just take a minute to tell you about LegalVision's membership. This is a cost-effective alternative to the expensive hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services including unlimited document review, drafting, amending and reviewing business contracts, commercial leases. You can get unlimited advice consultations with our team of over 100 lawyers. You can also get access to unlimited domestic trademark applications. As a member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house legal counsel. We'll take care of all the business as usual legal work, and you can focus on running your business. And if you are in-house legal counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how membership can help you, request a free consultation when the survey appears at the end of this webinar. And now let's jump into a couple of questions, shall we, Blake?
Yep, thanks, Rebecca. So one of the first questions was, for a business with only one product, what are the costs and benefits of obtaining a trademark for the product? Well, the costs really depend on how you go. If you were to file the trademark directly yourself without having the benefit of a legal representative, the official fee for one product probably falls within one class of goods or services, and the official fees can be around $250. So very reasonable. What are the benefits? Rebecca's already sort of spoken about some of the benefits that come from the statutory protection that a registered trademark gives, but I would just re-emphasize that if you're ever in a dispute about your trademark, you're on much stronger ground if you've got a registered trademark than if you're trying to rely on unregistered trademark rights. You also have greater access to things such as online marketplace and social media dispute resolution mechanisms. So, you know, platforms like Facebook, eBay, you know, they have complaint forms where if you own a registered trademark, you can complain if someone is using something that potentially infringes your trademark. You can't do that if you just have unregistered trademark rights. They will only accept complaints based on registered trademarks. The other disadvantage of unregistered trademarks is that they can be ring-fenced quite easily. So although you might have a reputation and you can enforce your registered trademark, it's usually only in regard to what you're actually doing specifically, and perhaps a sort of a slight extension around that. A registered trademark, you have the benefit of very broad tests for what are similar goods and services. So definitely a registered trademark has much greater benefits over an unregistered trademark in terms of enforceability and use of dispute resolution mechanisms. Rebecca.
Fantastic, thanks Blake. Now the next question we've got here is, I have an established hair and beauty home studio business. I wish to protect the name. I am in the process of developing a web page, Facebook and newspaper advertising in view of business growth all going well. What steps should I take? So the first thing I would say is definitely carry out some clearance searching before you launch your website, Facebook and other advertising. When you become more visible is often when issues might arise. So perhaps you've been operating under a particular brand name in your home studio, and there might be some conflicting business name out there or someone using a similar brand, but perhaps they haven't become aware of you yet. So before you go expanding and extending your reach in the marketplace and your advertising, it's good to check that you are in fact clear to use that trademark. The other thing I'd say is get your trademark application filed as soon as possible, because that will secure you a priority date and get the process started. As Blake mentioned earlier, it can take a few months or up to 6, 7, 8 months to get your trademark registered if it all goes smoothly. So it's good to get the process underway as soon as possible. I'd also say think about what you want to register. So if your trademark is distinctive, it might be registerable as a word for broad protection. If you have a logo, you might file that as well to protect the visual elements in your brand. And the other thing to think about would be the scope of protection. So class 44 would cover your beauty and hair services, but if you're looking at perhaps developing a product in the future, you might need class 3 protection, or if you're retailing third-party products within your salon, then you might need class 35 protection for retail services. Over to you, Blake.
Okay, so another good question. What is the difference between Australian, New Zealand and international trademarks? Okay, so this touches on a topic that could probably be the subject of another webinar, which is filing and protecting your trademarks overseas. But basically, trademarks are given protection separately in each country. And there's two ways that you can apply in different countries. One is you can apply directly by going to a trademarks office in a particular country, such as New Zealand. The other way is you can file an international application via what we call the Madrid Protocol. And that's just a way of filing applications in different designated countries through a central point. The trademark is then examined and registered under the laws of each country separately. But Australian and New Zealand trademarks are very similar in a lot of ways. They have very similar tests for registration. The process is similar in terms of what happens once the trademark is filed. The cost is similar, although New Zealand is a little bit cheaper than us. And the opposition process, has a lot of similarities as well. So filing in New Zealand will be a similar experience to filing in Australia, but there are pitfalls and traps, and the law does differ in certain key respects. So always important to get some legal advice if you're going to file in other countries. Rebecca.
Thanks, Blake. I might just squeeze one more question in here now. Should I trademark my brand or company name? What would make the answer yes rather than no, and at what stage of the company's life should I do it? So normally you would protect your brand name by trademark registration, but often your brand name and your company name can be one and the same. As an example, Google is a company name, but it was also the name of the search engine which Google provides. So it really depends on if your company name is client-facing or if it's purely operational. For example, if your Pty Ltd name is ABC123 Pty Ltd, but you're trading under an unrelated business name as your brand and customers perhaps aren't even aware of your Pty Ltd name, then you may not need trademark protection for your company name, just the business name. An example where both are separate trademarks would be Apple. So Apple is the company name, but we as consumers also recognize it as a trademark. iPhone, on the other hand, is the brand name for a particular subset of products that Apple provides. But in this scenario, both Apple and iPhone are trademarks. And I hope that was useful. We have heaps of questions here. Sorry to everyone that we didn't get to, but we will follow up with those people, book in a time to chat through your queries and answer any questions that you have. So we'd really appreciate it if you could please complete the 30-second survey at the end of this webinar. Please include your contact details to receive a complimentary legal consultation to discuss how we can help you with your trademark protection. And thank you very much again to Kathryn and Blake for joining us today.
Thank you for having us. Cheers.